The news media reported that the department used compulsory process to get records of members of Congress, oh my gosh, and congressional staffers in connection with unauthorized disclosure of classified info. The Biden DOJ was spying on Congress. The department revised their policies again, okay? So this happens every time. I don't care if the DOJ revised their policies. They made the policies in the first place to be illegal. The Department of Justice allegedly spied on a bunch of Congress people, including Kash Patel, another official who wasn't in Congress at the time, but was working in the government. What was the DOJ doing? Well, we're going to dig into this report that came out from the Office of the Inspector General, supposed to be investigating the DOJ. But as we know, they like to investigate themselves and find they did nothing wrong because they're the Department of Justice. Now here, this is a summary of what is inside from our friend Tristan Levitt, who's been on this channel before because him and Jason Foster put together the Empower Oversight body that was representing the IRS whistleblowers. You remember that story. And so he's saying, by the way, they got spied on too. According to the OIG report, that explains how the DOJ accessed records from Congress people and 43 staffers, including Jason Foster and Kash Patel. This needs to spark major reforms, okay? They're not supposed to be investigating and commandeering information from a co-equal branch of government, but that's exactly what they're doing. So here's what this report says. Here's a review of the DOJ's issuance of compulsory process, so subpoenas or records demands, to get records from Congress, staffers, and the news media. Our corrupt DOJ spying on everybody. Now, here is the executive summary in the background. In the spring and summer of 2017, we had different organizations like CNN, the New York Times, the Washington Post. They were publishing articles containing classified information, some of which was top secret and sensitive compartmented information, okay? Media publishing top secret info. In May and June, multiple news outlets reported that the DOJ issued compulsory process to get the records of the media. Okay, those are subpoenas. So we want your records and we're going to get them. Why? They said, we're going to identify who leaked this info. Now, the department's use of compulsory process was an encroachment on the news. They're allowed to publish that crap. Concerns also were raised about the department's use of non-disclosure orders. Okay, so the DOJ would then prevent the reporters and the news people from learning about the subpoena and to get their email records. So we are going to seize your records and we're going to make the court order you to not know about it. And if you do know about it, to not disclose it. Such NDOs could prevent reporters and news media companies from having an opportunity to even challenge the process. Now, concerns also were expressed that these orders impeded their ability to report on the orders. I mean, we can't even talk about your gag of us, thereby hindering public scrutiny of the government's activities. In addition, the news media was troubled by their lack of notice. And this was happening in 14 because in 2014 and 15, Obama was doing something similarly, and they changed their rules to favor notice and to warn people before they go commandeer their emails. Then on May 21st, 2021, Joe Biden stated that the practice of subpoenaing news media records, he said it was wrong. Simply wrong. And he's not going to allow it. The department is no longer going to seek any compulsory legal process for the news media. But then, right after they made that change, the news media reported that the department used compulsory process to get records of members of Congress, oh my gosh, and congressional staffers in connection with unauthorized disclosure of classified info. The Biden DOJ was spying on Congress. In response to this reporting, members of Congress expressed concerns that their records had been obtained for political reasons, and the compulsory process violated separation of powers. Similar to their criticism, they also voiced concerns about the use of NDOs to prohibit communication service providers from even disclosing the existence of the process, okay? So our Congress is so pathetic. I gotta tell you, man, every time we read one of these letters, it's just like, how badly do they want to be abused? The DOJ was stealing congressional emails and then going through a process to hide that from you. And our Congress people still sit around like morons and talk about whether Kash Patel is going to be good at the FBI or whether Pam Bondi is going to be good at the DOJ. On June 11th, the DOJ, Office of Inspector General, so the DOJ creates offices that investigate themselves. Okay, great. They initiated a review to examine this process and what happened here. And so we did that. This report summarizes the results of our review and how the DOJ used subpoenas and compulsory process, right? These are not even like public subpoenas. There's like secret letters to the courts to get records from members of Congress, congressional staffers, members of the news media in 4 criminal investigations into disclosure of classified documents. The department did not charge anyone in these investigations with unauthorized disclosure non-disclosure, and all 4 investigations are now closed, but not before they stole their records. Now, as described in this report, we make several findings about the department's use of these compulsory processes. With respect to members of Congress and congressional staff, which are the focus of Chapter 2, we found that the department issued compulsory process for the non-content communications of 2 members of Congress. Who are they? 43 individuals who were congressional staffers at the time, and both members were Democrats. Oh, and of the 43 congressional staffers, 21 worked for Democrat members of Congress, while 20 worked for Republicans. And by the way, I don't think that the FBI only goes after Republicans. I think they also want the Democrats wrapped around their thumb. I mean, I think that's probably why the Democrats are wrapped around their thumbs, is because they've got them under their control. Now, all of the members and staffers whose records were sought became aware of the classified information in connection with their congressional responsibilities. For most of the staffers, the basis of including them in the possible leakers was that the U.S. intelligence community determined that they had been provided access to this information. So in other words, there's no real cause to target these people. They've already had lawful access to this. So the decision to issue compulsory process was based on close proximity that they were enabled to have. Now, during the relevant time frame of this review, the department did not have a policy that expressly or clearly addressed the use of process to get this info from members of Congress. And the policy did not require any supervision at all, so they could do whatever they wanted because they're the FBI. Now, the department's decision to compel the production of this non-content communications implicated the constitutional rights and authorities of Congresspeople. Although members of Congress are not immune for prosecution from criminal conduct, you hear that, Liz Cheney, including the unauthorized disclosure of classified info, and we did not find any evidence of retaliatory or political motivation by the career prosecutors who issued these processes, we believe that this process, based solely on the fact that they're close to the information, is chilling Congress's ability to conduct oversight. It exposes congressional officials to having their records reviewed by the department because they were doing their jobs. You say there's an inappropriate inference by the executive branch, but they were doing their job. You have no right to investigate them for doing their job. Moreover, even non-content communications, which is just like the metadata, right? Like, did you send text messages at this time? Not what's in the text messages at that time. They can reveal sensitive communications of Congress and whistleblowers and other interest groups, and it's protected by the First Amendment. You have no right to do it. We are also determined that the department got 40 of these non-disclosure orders related to the compulsory process that was issued for members of Congress. Some of those were extended for up to 4 years of spying. The applications filed with the courts relied on general assertions about the need for non-disclosure rather than on case-specific justifications. So they just said, well, we're just scared about, stupid things like the administration of justice. And so we have to do whatever we want in order to prevent bad things from happening. And then what does the court say? Oh, of course you do. And we trust you because you're government prosecutors. So therefore, whatever you want. Department policy permits prosecutors to make boilerplate statements and applications. However, it says they should have specific facts that are relevant to the review. The renewal applications included in this investigation did not have anything new. It was the same boilerplate assertions about the need for non-disclosure. And so it was just a copy and paste recitation as they always do. In November of 2023, the department substantially revised its policy on this after there were complaints. The revised policy also stated that they should, not shall, should, which is discretionary, notify when they were making these decisions. But that's not good enough. And so we now recommend you evaluate notification, whether members of Congress should be notified, and how these things are processed. Now, after reviewing a draft of this report, the department revised their policies again. Okay, so this happens every time. I don't care if the DOJ revised their policies. They made the policies in the first place to be illegal. So just because they changed them because somebody complained doesn't mean that original illegality goes without scrutiny. The newly revised investigations policy now requires that they notify somebody. The newly revised policy makes explicit that anything related to this, you must, okay, see how it went from should to a must? They're not morons. They know what that word means. That's why they wrote it. Oh, you should notify. Should? What if I don't want to? Well, you don't have to. You should, but you don't have to. So that sounds good. That's better than don't notify. So, okay, maybe we'll leave it discretionary, right? Then they change it like, oh, somebody complained. Now you must file. Okay, now it's non-discretionary. But the people who wrote this word in there, they knew what they were doing. These are lawyers. They work for the DOJ. They know exactly what they're doing. So the people responsible for this little policy that resulted in Congress people being spied upon, there should be repercussions for that. Hopefully we know who their names are. At the same time, the department also revised the urgent reports policy to explicitly add investigations and other things. And so you got to file this stuff with the court. Now, our review also observed that while some of the department's former and current news media policies exhaust all reasonable avenues to obtain the information through other means, we recommend that they consider where there are circumstances, can you just default and just say, give us your emails? Or should you have to go try to investigate it otherwise? They just go right to the emails because they can. With respect to compulsory process to obtain communication, members of the news media, the department has emphasized the need to ensure the highest level of oversight. However, in the 3 investigations that we looked at, we found that the department complied with some, but not all of the applicable provisions of their news media policy. We found that the department failed to convene the review committee to consider the process. They did not obtain the required director certification from the Director of National Intelligence. So it says you must do this, and they don't. And we were unable to confirm whether the DNI certification it attained in another case was provided to the AG before he even authorized the request. So they're doing it, but nobody's actually checking anything. And the department did not get the AG's express authorization in connection with these other compulsory processes. And so given the important interest here, we were troubled that these failures occurred, particularly given that only a few years had elapsed since the department substantially overhauled its news media policies after there were criticisms. Having once again reviewed it, they must make every effort to ensure exacting compliance with this new policy in the future. They know what they're doing. I'm so tired of this. It's like our government bureaucrats always default to we're just incompetent and we didn't know any better. No, you guys knew better. You knew exactly what you were doing and you were spying on the news media. Where's the Washington Post, CNN, and New York Times coming out and screaming at them about this? Here's the full report. The FBI did take and store records. According to the information the FBI gave to us, the FBI retains the redacted containing records of redacted obtained by the Washington Post. The FBI further told us they got a digital copy of some of the records of the Washington Post, also stored in the FBI's case, and they have copies of this and this, all locked in a filing cabinet. The FBI told us that blank and blank contained the records of blank, and so obtained those from the Washington Post too. They got records of the news media. Well, let's look at Congress. Then they went after Congress and congressional staffers. Although federal law does not recognize a reporter's privilege, the department has imposed strictures on itself that they then violated. They had a news media policy, and then they promulgated new congressional rules. They conducted oversight into Congress. In exercising its oversight authority, Congress has the right to investigate the executive branch. That's their oversight authority. Now, they interviewed 24 witnesses. They talked to people from the New York Times and Washington Post and other places. Members of the news media got commandeered. So we'll keep our eye on it. Fortunately, Kash Patel is going to be coming in soon, and maybe he'll find out who did the spying.